All right, what's up, everybody? Today is going to be the 13th of March, 14th of March. It's a great day, 2026. Gavin Mehl, we got a mastermind call today. And so it's going to be a call actually, if you ever had a problem with something on your credit before, I'm going to tell you my story about how I finally, after years, got this one derogatory mark off my credit through the most, it was complicated because it took me years to figure out, but it was simple once I got it. And then also the fraud and the leasing contracts that have been going on, leasing and auto sales contracts in California, and the exact particular statute that governs these people, and how, nobody seems to be going to court on this yet. There's no published case on it yet. I'm going to break this down, and how we all can benefit from one, if we have one derogatory thing on our credit, it can harm you so bad, like it can really affect you. And, it's like one little thing. And I'll show you exactly how I finally got this thing off. And then I had like I said, this auto and leasing contract law, which I figured out this week was a huge breakthrough. So yeah, disclaimer, no, nothing's legal advice. Get your own legal advice, get your own freaking counsel, do your own research and all this stuff. None of it should be considered anything serious or just all entertainment purposes only. Now, here's the deal. I'll tell you the story. So 2016, I had bankruptcy. Boo hoo hoo. Everybody, has a hard time and whatever. I had to do bankruptcy. It was hell. It was shit. It was a bad time. Okay. And I got bankruptcy, and then I got, after the bankruptcy, I finally got a secured credit card. Then I finally got a secured credit card around 20, I don't know, shortly thereafter, because, they won't give you credit after you're bankrupt. So I got the secured credit card, and I put the money in there. And then I went back to some old bad habits that I had. And I thought, oh, I'm going to challenge this debt. I'm going to dispute it. I'm going to do a bonded promissory note or whatever BS I was thinking at the time. And I didn't pay off my debt on the secured credit. And so it sat on my credit, went to charge off, and it went to collections or whatever. It didn't go to collections, went to charge off. But it sat on there forever. Like, it sat on there. It was on there. Okay, it's been on there since the card was really 2019. I think it went to default like shortly thereafter. I was really irresponsible with it at the time. And so here's the thing: is that I challenged it literally like 60 times. I was obsessed with getting that thing off. I hired this scam law firm called Lexington Law. They got sued for class action. I got a settlement for 50 cents out of it. And then never do that. So then, I pursued it on my own, tried a bunch of different ways, challenging the credit. But because of the teaching I had from Brother Sharif from Ron Cup that he gave me, it was actually, I learned consumer protection law. And, through all that nonsense, I didn't study consumer protection law for this one little secured card debt, but it's just kind of the end up result. Like, I got some proof here that it worked. And that was understanding the Fair Credit Reporting Act, because you got the Rosenthal Act, you got the FDCPA, which is the federal law against debt collectors. And I tried these. This was Wells Fargo. I'd written to Wells Fargo a bunch of times, and they would not take it off my credit. And they kept saying it was my debt. That was their reason. It's your debt. And they ended up sending me a contract that I actually signed with my physical signature on it. I thought, wow, man, they got my signature on there. That does look like me. I don't even remember doing that, but okay. So apparently I went into the bank and I signed for the card, at one point. And so it was mine. They actually had a signature and everything, so it was legit. But they never sent it to a collection company. And so they never sent it to a collection company. It was kind of like not a debt collector issue. They were collecting on their own debt. So technically they were the creditor. They have this little thing called WNBNA, which is an affiliate of Wells Fargo. It's a debt collector, but it hides under the Wells Fargo brand name. And I never got to challenge that in court. So it's just a gripe that I have. But here's the bottom line. As opposed to doing it under the FDCPA, I figured out FDCPA, and I started challenging it that way. Now, I always challenged it the wrong way before, and I thought, oh, that's not my debt. That's not my debt, or identity theft or something. And, nothing ever worked. It wasn't until I figured out the mandatory duty on the regular, what's called the duty of the furnisher. Now, the furnisher is the credit reporting agency. That's Equifax, Experian, TransUnion. They have a mandatory duty to accurately report your debt. Now, that means that if you have one debt on Experian, one debt on TransUnion, and one debt on Equifax, and they're all reporting differently, slightly, that's inaccurate. That is an inaccurate reporting, and it could harm me. And in my case particularly, I finally got a tri-merge credit report before I would always just go to Experian, TransUnion, and Equifax. I would recommend that everybody just do that because it's free and you get your credit report that way. And you go right to the source. You don't pay anything. You don't need all this other stuff. So I'd always do it that way, but it makes it a little harder to read them all lined up together. But I had this one collection charge off, Wells Fargo on there, and it was nagging me and it was affecting me majorly on my score. Major 30% of my thing was this one old charge off. So it was a big deal. I mean, how bad this one thing was. So finally, I figured out that it was reporting where it was going to come off. Equifax was reporting that it was going to come off in October of this year. TransUnion reported that it was going to come off in September of this year. This was the breakthrough by looking at it and realizing, like, wait a second, there's a big difference here. One debt collector, one party, one credit reporting agency says it's going to come off in October. One of them says September. So what I did was I wrote a letter. I drafted up a letter to these people, and I just straight up said, I want you guys to look at I dispute my debt on this. And I wrote it and I said, look, account number, I listed the account number, and I put in a nice chart, I had Claude, or I think it was Claude 4.6, help me write this in a nice formatted way. Or maybe Claude Opus. And then I had Equifax, TransUnion, Experian. I listed it out in a nice chart. Let me share my screen on it because it's so clean. And this worked so I can share it. So let me show you here. All right. So that's how I listed it out, really clean. Look, Equifax, TransUnion, Experian. I had this account number, date of first delinquency, October 2019. It wasn't disclosed on these. So this was something that was different on the other bureaus. Estimated removal date, October 2026. TransUnion, September 2026. That right there was harming me because if it's not coming off on until October there, I can't apply for credit and get good rates until October. But if on TransUnion, I did it in September. So that was inaccurate. So I wrote to them and I said, I need you to please investigate this. You have a duty to report data accurately. And I'm being harmed because of it. And I attached all the exhibits to it. And I had already disputed this so many times like this that I just went directly to the CFPB. Now, the CFPB, what it does is it electronically sends it to them in a way to where I put it in there and it all goes to them at the same time. So I don't have to send a certified letter and wait, 10, 15, 30 days. It goes to them right away. I did it on a Friday night of like 2 weeks ago on the 27th. And by Monday, they were responding, if not sooner, saying they got it. So my demand was to please. Basically, they had what's called 15 U.S.C. This is the Fair Credit Reporting Act, and there's a specific statute that's S2A 5A. It imposes a duty on the furnishers to accurately report specific month and year of the delinquency to all consumer reporting agencies. So they've got to report that accurately. If it's not accurate, it's got to come off. This is a strict requirement, and this is what's called strict statutory law, not common law, not discretionary. This is administrative, pure, strict statutory by the furnisher, which is the credit reporting agency. They have to keep it all reported strict. So that's 1681CA4 is the strict required to calculate the right reporting limit. Meaning, like, when is it going to come off? They've got to report that accurately. Furthermore, it's widely inconsistent across the bureaus. So each bureau was reporting it differently, and that's also prohibited. Now, the Fair Credit Reporting Act 1681, which is et sec et al, is ratified. I'm sorry, what happened is that Congress put together this team of attorneys and they do what's called the Code of Federal Regulations, and they write regulations which aren't law but they're advisory over the statutes. And so in this case, it's great to put the CFR in there and find out where the CFR is and what it says, because it's advisory and it is important, and it helps to govern these agencies when you're disputing something like this, because it shows them, look, right here, 12 CFR and 12 CFR 1022, 42 and 41 both say that the requirement of the furnishers to establish reasonable policies to ensure accuracy and the integrity of the furnished information. So they've got to have policies to handle this. And so my demand was just to take it off. Now, I wrote to them and asked them, they had 30 days to respond. And I sent it to the Consumer Financial Protection Bureau online. You see right there. I sent it to them. That was the easiest way to do it. It was free, fast, no postage, and I'd already disputed it with them directly. I'd already done the FDCPA dispute with the debt collector directly, and that didn't work many times. And then I went to the furnisher, which is each credit reporting agency, a number of times. That didn't work. And then it was finally, I'd already done CFPB complaints before. None of it worked, but I was never laser focused on this one inaccurate issue. I never had a good enough understanding in the law why the inaccuracy is such a big deal. Again, so Equifax writes back to me right away. And they say, we investigated and we found that this was your debt. It's your debt. Have a nice day. So I'm like, wait a second, my debt? This letter does not dispute whether this is my debt or not. I didn't say this isn't my debt. That's not what I said. I said, I'm disputing the accuracy of this reporting. So I thought that was a problem. So then yesterday, I checked my report, and I'm like on this like a hawk. Yesterday morning, TransUnion pulls it off, and they've been reporting on it since 2019, like this right there, not disclosed. Actually, well, they said it was going to come off in 2026. They pulled it off, and once it came off of there, I thought, oh my gosh, I'm going to call Equifax right now. And I got on the phone with Equifax. Equifax, they'd been sued in these consumer protection lawsuits and class actions for breach of data. So, they really cleaned up their act before. I remember like 15 years ago, they were so bad, they were just rogue. You'd never, good luck. They don't give a shit about you. But now they've cleaned up their act. They've hired people on the phone that take the call and actually help them manage this stuff. So I called them on the phone, talked to the agency, and I got a lady on the phone, and I had to really kind of slow my roll because she was not thinking as fast as I was. So I had to be patient, which is hard for me at times, but tolerance. And I said, look, an hour on the call, I walked her through it. And I said, can you please pull up the document that I sent you? Because she said, oh, well, if you want me to look at this, I need a document. I said, well, good. I've already got a document for you to review. And this is like a 16-page document with all the exhibits showing the inaccuracy. So I get on the phone with her, patiently walk her through it. I show her on the phone where it was inaccurate from Equifax, from TransUnion, and Experian on each one. Slowly, took very patient on the call, and it was very hard to do. But then after 1 hour, she agreed. And she says, I'm taking it off. And so Equifax pulled it off just because of that phone call after going through it with them on the document. Now, I'd done that so many times. I had this garbage attorney firm, Lexington Law, which got sued over this. They never did it once. And I've been paying them monthly for years. They never could do it. They would just send boilerplate letters. None of that ever worked. So it was getting on the phone, and it finally took it off. It was amazing, so that was my major success story on the freaking credit, which and if you guys aren't, I know people have had problems with their credit, but I did too. Like I said, I had that bankruptcy and I had that charge off, which haunted me for years. I couldn't do anything, but now I've been slowly, building it back up, realizing how important credit is. And it's actually not because I want to get debt. That's not why. I actually don't want debt, for the credit, but I want what's called a high credit, availability so that I can do business credit. That's the magic, because they can't give you business credit unless you have good personal credit, and the business credit doesn't go on your personal credit. So I'll be able to keep my personal credit open, not because I want debt. I don't want debt on there. I just needed to have it all opened up and with good low, utilization, lines, and then a very high score. So then I go to the bank and they'll give you no doc loans at 0%. That's what's happening right now. And so, and it's not about using the money or getting the debt from the business credit. I don't even want to use the money, but having all the lines is where the value is. If you got $250,000 in available credit on your business, well, good, leave it there. I don't need the money. But when the time comes and something is 1 cent on the dollar, 2 cents on the dollar, oh yeah, that money is ready to go. Trust me. And that's how the super rich people do it, is that money on their credit lines is ready to go when the market crashes or whatever, the best possible deal. Not to spend the money to party. It's about waiting, having it there for the right opportunity. And again, it's 0%, and the 0% can roll over, every single month. Every single year. There's ways to get it rolled over to basically have infinite 0% money. So that's a huge success story. Now, the other thing I've been working on, which I want to share with you guys, which is massive, is the California leasing and auto sales law, which is huge, because if you guys think back, on any lease or auto sales purchase contract that you may have signed in California, there's these dealers, and what they do is I'll share this on the screen. What happens is they take that you walk in. So here's what happened. We walk into the dealer to get this car, and we're kind of surprised, basically. Oh, I'll give you the story. We're kind of surprised. It's me and my buddy, and we're like, well, we want to buy the car, but we might want to lease the car, but we want to make sure it's the best deal. We weren't 100% sure, so we'll go and kind of feel it out. So we get down there. They got the cars all outside, and the car's in our name. It says his name on it, and he's got the perfect credit, so he's buying everything on his credit. So I'm like, okay, at the time. Now I'm getting there, but so anyways, we get in there, and there's no contract given to us in the signing place at all, which is. They don't even present a contract. And I'm like a contract guy. I like to read contracts, as crazy as it sounds, but I actually think it's valuable. I want to read it. Oh no, we don't. We ask for the contract. So what comes out is this little tab. I'll show you what it looks like here. It's they present this Synotac tab, and the Synotac tab is just this. It's an electronic tablet, it's an electronic signature pad, not a tablet or a computer or even a document to read the contract. It's just a pad. And it's this little boiler, this pen, or you can just put your finger scribbling on there. And then when you take it, this is where the red flag popped up. It says, I, John Doe, have received and read the present contract documents and agree to the contents. So at this point, my buddy, he objects and he goes, excuse me, where's the contract? It says here, I have received and read the contract. Where's that? And then the guy at the dealership, the finance manager at the dealer, he goes, oh, that's not how we do it here. He's like, what do you mean, do what? It says I've read the contract. Where's the contract for me to read? Oh, well, we don't do it that way. What do you mean you don't do it that way? It says on here, I read and got the contract. I mean, you want me to lie? And then the dealer pulls the bait and switch, well, if you don't sign it right now, these cars are once in a lifetime, the whole sales pitch deal, right? And my buddy had driven 250 miles to get down there. He promised this car to his fiance, one of the cars, that oh, I'm getting you this car. We're getting married. This is going to be a great car for you. She's going to love it. So he's kind of in this situation where. So he demands the contract. They wouldn't give it to him. And then there's this kind of back and forth where it's like, all right, well, can I get out of the contract? Can I cancel the contract if I don't read it? You're not going to print the contract for me. No, we don't do it that way. And you're not going to get the deal if you don't. So, okay. So there's this back and forth argument inside the place, and I'm a witness. And so we go in there, and then they don't print the contract. And finally he's like, all right, well, as long as I can cancel the deal later, then fine. So they print it. So he signs the thing on this tablet, never gets the contract. And then after that, the contract comes out. It says there's no cancellation on the deal. You cannot cancel ever. I guess they've changed. Not that they've changed, but in the consumer laws, you can always usually cancel everything. But apparently in California, if you have what's called a lease contract, you're not allowed to cancel ever. That's just the way it works. So they make you sign that contract, and you can't get out of it. There's no way around it. So the only way to do anything about the contract is through fraud. Now, what I figured out is there's only a few articles that have come out about this, but there's a really good one. I mean, like no case law at all. None. It's never really even been to court. And so I've got this one article I found last night. It talks about the leasing act. It's from an attorney. I found a few of them, but I'll pull the one up here that I want to share because it's so relevant. Okay. Yeah. All right. Maybe I can't find it right now. Block. Buyer's remedies. Yeah, there it is. Black law. Okay, there's a number of remedies. So anyways, there's an attorney firm in San Francisco that talks about this exact thing. And they mentioned that if you signed a auto and sales leasing contract, that you were required to sign it under the actual statute itself. Now let me actually pull this up because I have to show this to you. I have to at least get the right statute. Here it is. California requires a wedding signature. Yeah. This one from this guy Madison is probably the best one that I found. So let me pull this one up. Madison, whatever, Madison law firm. It says California still requires a wet signature. Now this is another attorney, and what happened is all these companies are lobbying against this. They do not want this to happen. So you get big auto lobbying against this from happening. And this guy's actually a part of the auto lobby, and he's warning his clients, and he's saying electronic signatures in sales vehicles. He says, I sometimes get calls from my auto clients wondering if they still need to do the old physical signature. You know, that's what his article's saying. And he's writing to them. He's warning them. He's like, yeah, you have to do it. That's the law. This article is from 2018, but the law hasn't changed. There's a bunch of bills. They've been trying to overturn this old law, but it hasn't changed. So it says section 1633.7 goes on to state that a contract may not be denied the legal effect or enforceability solely because an electronic record was used in its formation. That is if it doesn't fit under one of these exclusions. Here's the kicker. It says, if the law requires a signature, an electronic signature satisfies the law. So that's the Electronic Signatures Law Act, like UETL in California law. So for the most part, it works on everything. There's like this blanket. It's fine. However, there's exceptions. And it says here, for the reasons stated in the law, California has exempted new and used vehicle sales and leases. All vehicle sales and leases are exempted. That's 1633C. So electronic documentation is fine for the DMV. You can register your car that way and do all that, transfer your title that way. That's actually fine in the DMV vehicle code. But this is the purchase and sales contract for new and used vehicles under the law. It says down here that there is an exception under this law, and it's under C, and it's really kind of a nuance and hard to actually navigate this. They make it extremely complicated, but I'll pull up the legislative thing really quick just to show you. 1633. So Civil Code 1633.3, and then you have to scroll down to subsection C. This title does not apply to any specific transaction described in this, and it goes through all these different laws, and then you have to. And this particular Vehicle Leasing Act is 2985.7 right here. So 2985.7 is the exception. Hard to find this. I'm telling you, man. It was because of Claude, I think, that helped me. Claude Opus was the one that found this. Then it says here, see this Vehicle Leasing Act. Now, there's another provision in there for vehicle sales and also used sales. But this one's particular about the Leasing Act. It says it doesn't apply to this act, 2985.7. So because of that, these people are not having a valid contract. And there's a remedy when it's purchased under the purchase of the law. If the car is actually purchased, there's a remedy that says that you can actually just rescind the whole contract and get your money back and turn the car back in. Okay, there's a statutory remedy for that, for purchasing. Under this attorney breaks it all down. And I'd like to find that, but I've got it. I could share it in a minute. But ultimately, that is a huge remedy. So anybody who's done a purchase, sales, lease, used or new vehicle in the last number of years, if it wasn't signed by an electronic signature, if it was signed by an electronic signature by one of those little tablets that I showed, with just this ridiculous tablet, it's not even a tablet; it's a Sinopad. These are done through coercion, manipulation. Look at that. I've received and read all the documents. So then here's the kicker. They put a clause on the contract, and it says in this one contract I read, it was on 44, and it says, I waive my rights to the electronics, to physical signatures, and I agree to electronic signatures on this contract. Well, the California legislature, they've made it clear in the courts that oversee these laws that a contract can't be illegal, meaning that if the law says that the contract has to be signed with a blue ink pen and black ink pen, you can't write in the contract to say, well, you waive your right to that law. It says that for a reason, because the consumers are not sophisticated. They're called the least sophisticated consumers, and the auto dealers, and they had so many complaints, were taking advantage of these people, locking them into these leases or contracts that they couldn't get out of, ever. And they had no disclosures about the terms, high rates, whatever payments. They didn't like it. They didn't even know what they're buying, and they would sign it through pressure. And then they couldn't challenge it, so it would only be challenged through fraud. And so by having that provision in the contract where it says, oh, you waive your rights to a physical signature under this one in 44, that's totally contrary to the law. So it has to be settled by the court. That's my introduction here. So it's a great day, everybody. I want to just go on the record. How's everybody doing? Open up.